So we were asked to find that the disbanded unit was unconstitutional because it wasn't independent enough. And we were sitting 9 and we split 5-4. And 5 of us decided that it wasn't, that the international obligation from the UN Convention and the African Convention Against Corruption, the Southern African Development Community, all of these international conventions, we said, had constitutional force inside South Africa. And 5 of us ruled that, that this obligation to create a sufficiently independent institution had constitutional force, and we struck down the law that created this body that reported to the cabinet ministers. We said, how can you be independent if you're reporting to a committee of cabinet ministers who might themselves be part of your investigation? But it was a very close thing. It was 5. We started off, 2 of us, we had a judgment. 2 of us wrote a different judgment. We then became 3, we then became 4, and shortly before the judgment was delivered, we became 5. So it was very dramatic, as happens in courts that sit in panels. But we hope that it will continue this fight, because like my dear colleague from Africa, my fellow African, I think that this is the lifeblood, because I see it as a struggle between the attempt, under the rule of law, under law, to create independent institutions, and the biggest threat is not political power. The biggest threat is corruption.
Lots of hands going up.
Okay, so I was wondering if I could ask a question about social and economic rights, which, as you stated, in South Africa, we're probably one of the very few jurisdictions in the world where they're domestically enforceable. I was wondering if you could make a comment on the reconciliation of the group room decision with the reasonableness test in the South African Constitution. And I was also wondering if maybe if Lord Kerr could comment, or I don't know if he could in this current capacity, because I know the legislation is still going through a bit of parliamentary ping pong, but if he could comment on the Equalities Act 2010 and whether or not he would feel that such provisions contained in Part 1, with the exception maybe Part 3, would actually lead to enforceable or higher enforceable standards of second generation rights in this jurisdiction.
Well, I'd love to comment on that if I knew enough about it. But sadly I don't, and therefore I fascinate. I mean, the whole business of socio-economic rights is a very live one, especially in Northern Ireland, as you may know, where it's being proposed, and most notably by the Northern Ireland Human Rights Commission, that there should be a Bill of Rights for Northern Ireland, which will introduce socio-economic rights, such as exist in South Africa. I have to profess to be agnostic on that at present. I mean, we have a very, very useful resource, in my view, in the Human Rights Act, which incorporates the European Convention on Human Rights and fundamental freedoms. People often refer to it as the European Convention on Human Rights without forgetting, or without recalling that it's also fundamental freedoms. And it is proved, it's drawn at a very high level of abstraction, but it has proved an enormous resource in vindicating personal rights. Whether a Bill of Rights drawn at the same level of abstraction would have the impact that the Human Rights Act has had, I simply don't know. I don't know the answer to that.
I'm not going to answer your question in detail, because I think it might be something that we can talk about later. But what I want to explain is that we have exactly what Lord Kerr says in South Africa. We haven't protected only what lawyers call the first generation rights, what the Americans call the rights to be free from governmental interference. The American amendments to the Constitution say government shall make no law prohibiting freedom of expression, setting up a religion, and the American Bill of Rights is a classic set of commandments that says to the government, you may not interfere in people's lives. What social and economic rights do is to say to the government, get off your back. And you've got to go out, and you've got to, and the Grootboom case that my brother here mentioned was a case about a woman who was left stranded in the middle of the Western Cape winter, desperately cold and wet, and she didn't have emergency housing. The court said to the government, it doesn't help to tell us that you're building all these wonderful houses with good roofs and plumbing and electricity for people who need them. We accept that so many people need houses. 7 million people in South Africa are living in informal settlements. Your plan has to include provision for those who are in emergency circumstances. So the court struck down the government's housing plan in the Quirkham case. That was what is so dramatic about it. Now, the reasonableness standard you mentioned is a difficult one, because in South Africa you only have one social and economic right. That's the right to basic education. You can go to government whether you're 90 or 9 years old, and you can say, I want my right to basic education. There's very interesting litigation in one of our poorest provinces, the Eastern Cape province, right now about enforcing that right. All the other social and economic rights, as our colleague has said, are a right of access to water, to social security, to higher education, and to medical care. And the obligation on government is not to give those rights, but to take reasonable measures to secure access to the rights. So it puts us as judges in quite an interesting situation. And I want to tell you about one case, just quickly, if I may, Ingrid. It was a case about toilets. And you know how important toilets are. Toilets are terrifically important to people's dignity, and that's why I like this case. It was a case about an informal settlement outside Johannesburg, about 40 kilometers east of where the court sits. And the people there were going to be relocated. And they wanted toilets. They said, we wanted something called a VIP toilet. A VIP toilet is a ventilated, improved pit latrine. And we had enormous evidence about informal settlements, about the brick structures, about how deep you have to dig, about open pit toilets. And you know what we did in the end, and this is what this gentleman's question is about. We said, we're going to leave that decision to government to take. We're not going to order government to create these ventilated, these VIP toilets, because the government said to us, if you're going to make us create these VIP toilets for the Harry Gwala informal settlement, we're going to have to do it for all the informal settlements in which hundreds of thousands of people are living in Johannesburg. And that's going to mess up our plans. And we said, we've heard you. So it's very difficult, because that community wanted their VIP toilets, and we said to government, you can first decide whether you're going to relocate them, and if you're not going to relocate them, you've got to build those toilets, but until you've made that decision, we're not going to give an order against you. So I hope that answers part of your question.
Yes, I just want to know, if there are adequate provision for legal aid in South Africa, what are the mechanisms there?
There's a compulsory state legal aid for criminal cases, and there's very little legal aid for civil cases, going back to the question of our colleague at the back there.
I just wanted to make a quick contribution to what was said earlier. It was about the whole women in high, cool. That discussion anyway. I just wanted to say that I think it would be worth probably encouraging young people like ourselves, females, to think about that sort of option, because as a young person, if I hadn't had taken this opportunity of the Supreme Court, I wouldn't have been aware of the political issues and higher things that I can achieve in law. So possibly it will be worth just encouraging us young people in society to take on that bold step and become people like that, make that our aim, sort of thing.
Well, and I think what Lord Kerr said earlier about communicating your views, if you think it's important and that it will encourage your confidence in the judiciary, you should be telling the Judicial Appointments Commission and the people, the Ministry of Justice, the people who will be making those decisions, because your voices do matter, I think. Yeah.
Since the point was brought up like a second or third time, I want to sort of give like the opposite view. I don't think like setting quotas would be a terrible idea, but I don't think it would be a very good one, for a few reasons. Like if you said 50% must be female, for example, it might have like the opposite effect. In that way, like a man might not get that job just for being a man. And also, I feel like an employer should have the right to hire who he or she wants. So I don't think like I would oppose it, like if I was in government.
let's have somebody else who hasn't said anything.
On the same subject, actually, do you think that it has anything to do with actual ability? You were saying about how lots of black judges got appointed and not lots of work got done. Do you think it did the amount of like ethnic majority people, like mostly like men and women and then white and black? Do you think it has anything to do with actual ability?
That's such a good question, because it also has to do with opportunity and training. There are people with ability who haven't had the opportunity and who haven't had the training. That's why the women judges training course is so important. And it's not to do with ability at all, because two of the most powerful and clever lawyers in South Africa are black people, the Chief Justice and the Deputy Chief Justice. And you can check the internet for their judgments. They're wonderful judgments. Both of them write very powerful judgments. So the question is, how do you find people with the ability who haven't had the opportunity and who haven't had the training? And that's our job. It's not just a question of finding people with ability. The merit argument, I think, distorts that. And you've got to do what Lord Kerr says, which is to go out and to be proactive, to do what he did as chairman of his JAC, and to create the opportunity and to make the training available to people. Because those women and those minorities, and in our country the majority, they're there. The people of quality and the people of capability and people who are willing to work very hard are there.
Just something you guys might appreciate. I went to a show a couple of weeks ago which was about the issue of women and equality in society in general. And it was given by a comedian, and comedians now seem to have recognised as actually sometimes providing really astute insights into current social and political issues. And this guy opened his stand-up with a joke. Well, he started with a question and then followed it with a joke. And his question was, which country in the world has the highest number of women in its parliament, and in fact has almost equal women in parliament? And the answer is Rwanda. On current statistics, which were produced around 12 months to 2 years ago. And they did a study and they calculated how long it would take for the UK to reach a similar situation of having equal quota. And the answer was 240 years. That's how long it will take on current figures to get to that position. And so his answer to the quota question was, well, to be honest, you can either accept the quota system with all the problems and all the reservations you have, or you can wait 240 years. To me, I'll take the quota system. And that was his reply to it. And I think it provides a really interesting insight into that question and the question of passivity. We can say, oh, we're going to wait until women get to an equal position, we have opportunities. But the question is how long? And maybe the nuclear option does become more and more feasible as the years go on.
Yeah.
Unfortunately, I was late, so I couldn't have a chance to listen to various speeches. However, that doesn't prevent me to ask my question. Probably might be a general question, but I will address it to the judge from Ethiopia. And my question is, looking at the principles of access to justice, we talk about obtain legal assistance, participate effectively in the legal system, obtain assistance from non-legal advocacy and support. But my question is, these principles rise in the face of a Sharia law, which to me is a kind of a dictatorial regime. And why is Ethiopia embracing a Sharia law? And my second question is, I believe guilt is an individual like salvation. Why is it that in Ethiopia, people can be prosecuted from the crime their parents or relatives committed? And the third question is, why is in Ethiopia people are